According to alcoholhelp.com, alcoholism in the workplace can be extremely costly to employers. Drinking not only increases the possibility of employees getting injured, it can also lead to more occupational incidents and injuries. Additionally, alcohol can cause a lack of concentration and coordination in an employee's work performance. This reduces productivity, which in turn impacts business goals and objectives. Construction workers are 1.72 times more likely to die from alcohol-related death than an average person. This should worry us all. In their 2020 South African Medical Journal article titled Cannabis Legislation and Testing for Cannabis Use in Safety and Risk-Sensitive Environments, Dr. J.B. Lawrence and Dr. P.A. Castens warned us that confusing the stance of zero tolerance with zero concentration as a first approximation is not within the ambit of the Constitution and may infringe an individual's right to use cannabis lawfully and responsibly. However, they said that a clear and well-written prohibited substance regulation and testing policy is the starting point of the whole process to provide regulatory certainty for both the organization and the test subjects. They then concluded by saying that cannabis use examinations should be done with an approach similar to alcohol use, which requires additional diagnostic evidence beyond the mere presence of parent compound or metabolites above the threshold concentration applicable for risk and safety. Occupational medical and health practitioners are often pressurized to report and subject any employee testing positive for drugs and alcoholic substances based on a concept called zero tolerance policy. However, surprisingly, in most of these workplaces, alcohol and drug policies do not even exist to be implemented. So the question remains, how does one enforce a policy that does not exist? Colleagues, greetings, and please join us this evening as we unpack a very critical aspect of alcohol and cannabis use in the workplace and clearly define what it means to be intoxicated. I'm Dr. David Mkwanazi, an occupational medical practitioner, exposure scientist, and health professions educator. But most importantly, I'm a colleague of yours. My mission again today is to represent the Occupational Health and Exposure Sciences Academy as it aims to save workers, empower employers by enriching occupational health professionals with knowledge. Today's session is proudly brought to you by Occupational Health and Exposure Sciences Academy in partnership with Expert Laboratory Services. Expert Laboratory Services provides evidence-based solution at the interface of science and law. They provide services such as substance abuse policy development, seminars, workshops, and on-site training, point-of-care screening services, drug confirmation testing, consultation services, and expert testimonies in labor and civil courts. Visit their website on www.expertlabservices.co.za or contact them at 072 551 8412. I repeat, 072 551 8412. Colleagues, as always, we do acknowledge and show gratitude to all our panelists for sharing their knowledge with us this evening and urge you to reach out to them after this session to benefit from their expertise. Let us go through a couple of house rules. This session is accredited for 1 CPD point by HPCSA for registered participants. It is the second session of the year 2025, and there are more to come. Kindly please drop your HPCSA number, full names, and email address in the chat box to register for CPDs. For those who are not registered with HPCSA, an attendance certificate will be issued to demonstrate your growing knowledge capacity in areas covered by our platform. Please keep yourself muted at all times to avoid interrupting presenters. Disruptive attendees will be removed from the webinar and will not be able to join back again. This session's attendance will be monitored for its entire duration to ensure full attendance. Kindly please ensure that you do not join using nicknames or handset device names to be properly identified and allocated your points. Each session will be podcasted as usual on YouTube for long-term education and training purposes. We have realized that a lot of colleagues go back to our YouTube page to recap on the information that may have been missed during our sessions. We also urge you to post your questions on the video platform to continue empowering colleagues who will always be able to access our learning material. Participants will be allowed to ask questions or comment after all the sessions are completed. Questions can be posted in the chat box anytime during or after the presentation. Our sessions are multidisciplinary in nature and meant to empower colleagues from different professional backgrounds. Kindly please be patient during moments when we discuss topics that may not be relevant to you but others. Sit back and relax, colleagues. The webinar is about to start. In today's session, we discuss substance abuse policies and testing procedures. We will then discuss laboratory testing services for substance abuse. Then we'll discuss a few case law cases, and then we'll have a Q&A session afterwards. Tonight's session is slightly different from what we are used to. Our panelists will briefly outline some of the important aspects relating to their day-to-day profession and leave us with the opportunity to ask as many questions as we like. It's going to be a very memorable one, colleagues. Welcome. We are happy to introduce two much-needed short courses or micro-credentials that we will host on the 27th and the 28th of March on medical surveillance and risk management. This will be presented face-to-face in Vereeniging and simultaneously online to colleagues who will not be able to travel. As per tradition, we will cover both the theoretical and practical aspects of these two subjects. These two courses will be accredited for a total of 5 CPD points each by the HPCSA. Details and registration link can be obtained from ohesa.dlp@gmail.com. ohesa.dlp for digital learning platform @gmail.com or on WhatsApp 064 520 3301 064 520 3301. Only a few spots are left, so please attend to it as soon as possible if you would like to be part of it. We are also having a comprehensive economic management course spanning over 5 days in June. Details will be communicated closer to the date, and registrations are already open. Thank you. Colleagues, when it comes to regulating the use of drugs, alcohol, and cannabis in the workplace, there's one important document that is there to guide us. One can say it's a user manual for this kind of service. It's called a policy document on substance abuse or alcohol or cannabis use. As you know, a policy document in the workplace is a document that provides guidance in terms of what needs to be done, procedures to be followed, how certain aspects of the subjects must be handled. In this case, the testing of the alcohol in the workplace. What is the benefit of having the policy? It guides us to be able to manage all the cases uniformly without deviations and making sure we consider the law in all aspects of this substance abuse management. Usually the EHS or Environmental Health and Safety Department will be responsible for drafting the policy, but from time to time, occupational nurses or doctors will also be asked for their input. And the custodian of this policy is usually EHS or SHEC or Health and Safety Committee. The health and safety people, as well as occupational health or occupational medical practitioner, are responsible for enforcing the policy. So somebody drafts the policy, but like any other piece of legislation or any other piece of law, somebody has to manage or administer or enforce this law, or in this case, these guidelines or this policy. Does a zero tolerance principle replace the policy? I think this is one of the questions that our panelists will answer at the later stage. But in my opinion, no. We can all talk that we have a zero tolerance in this company. As long as we don't have a policy, legally speaking or ethically speaking, we can't really enforce the policy that we don't have or the policy that does not exist. So having a zero tolerance is not meant to be just a mere word or statement. It's meant to be backed up by an existence of a policy. So a few aspects that need to be considered when drafting this policy. You need to outline the purpose definition, policy statement, the roles and responsibilities of people administering this policy and their obligations. You need to clearly define how it will be enforced and the application. You need to clearly outline the screening of alcohol or drug or cannabis use in the workplace, how it's going to be performed, the procedure that is to be followed when an employee tests positive for any of these substances. Special circumstances under which the policy will be applied or testing will be performed, such as random searches, such as when we have a suspicion that the employee might be intoxicated. And again, we need to outline the assistance that will be offered to these employees should we determine them to be incapacitated. Remember, drug abuse in the eyes of the law or medically speaking can also be seen as an incapacity and not mere misconduct. And if in a case where we decide it's an incapacity or where the employee is addicted, medically speaking, we have to manage it as an incapacity. And then we also need to outline the disciplinary procedure that will be followed for those who will be found to be transgressing. And then in terms of testing, workplace substance testing for procedures, this must be performed. Typically, it's performed at the gate by the security officers, but the law usually says a competent person. And my understanding of a competent person is somebody who has been trained adequately, whose training can be proven or determined to perform such a test. So it's usually performed at the gate or at the entrance, sometimes in the clinic when we perform our medical assessments. Like I've said, usually in the clinic or at the entrance of the company premises. And we normally do testing before employees are employed, or in certain circumstances, high-risk employee groups, such as working at heights, confined spaces, and drivers, we normally test them as well because of the risk we might face if they are found to be intoxicated. And indications are pre-employment medicals, making sure everybody is healthy and safe in the workplace without infiltration of people who might be intoxicated. The procedure that we follow when we perform testing, first we counsel these patients. We explain to them why we want to test them. for what reason. We don't just test them, and we normally gain their consent and make sure they agree to testing. And then we'll follow the procedure. There will be a witness most of the times who will make sure that the employee is not coerced into being tested. And then following that, we'll share the results with the employee, and also considering that we need their consent to share results with others. Then there will be disclosure to the company and communication to third parties who are relevant. Due to the patient nature of these employees and the nature of, especially in the clinics, we always have to ask for their consent. And then intoxication. I think that's the main question when it comes to alcohol and substance abuse, because somebody will say anybody who smokes dagga or anybody who drinks alcohol, but the law is clear and the regulations are clear that we need to ensure whether the person is intoxicated or not. And in this case, you look for symptoms of intoxication. Just to mention a few, for cannabis, you look for euphoria, you look for anxiety, being uncontrollable laughter, increased appetite, inattentiveness, red eyes, dry mouth, forgetfulness, tachycardia, relentlessness, sometimes even psychosis, and you may be able to smell cannabis in his breath. And in the cases of alcohol, some patients or employees may black out. You look for unsteady gait, you look for poor movement coordination, nausea and vomiting at times, depression at times, euphoria, bloodshot eyes, nystagmus, and the smell of alcohol sometimes in the breath, and slurred speech. So those are the things that you look for. And then following all of this, once the patient is tested positive for alcohol or positive for cannabis, there's a new aspect that we need to consider, and it's called laboratory testing. To give us a bit on this, allow me to introduce Dr. Tim Lawrence, who holds a BSc degree from University of Pretoria, BSc Honours in Chemistry from the University of Pretoria, Masters of Science in Chemistry, University of Pretoria, Master of Science in Toxicology from University of Surrey in the United Kingdom, Master of Philosophy in Medical Law and Ethics, University of Pretoria, PhD in Chemistry, University of Pretoria, PhD in Medical Law and Ethics from the University of Pretoria, and LLB from University of South Africa. He's the Laboratory and Technical Director at Expert Laboratory Services, with experience of 40 years in chemical and forensic analysis in University of Pretoria. His research interests are in forensic toxicology, workplace drug testing, analytical chemistry, and the interface of science and law. He has about 30 publications, over 30 publications in international peer-reviewed scientific journals. He's a reviewer of scientific articles for international journals. He's a consultant for United Nations on forensic laboratories in Africa. He's an ISO 17025 SANAS assessor for forensic laboratories. Also provides expert testimony in South African courts. Affiliated with HPCSA as a registered medical biochemist. Also registered professional natural scientist. Also affiliated with the International Association of Forensic Toxicologists and International Society of Hair Testing. Please allow me to welcome Dr. Tim Lawrence. Lawrence, would you like to share?
Yes, good evening. Let me just. There you are. Can you see my slide?
I'm just stopping my share. Your slide is coming up. Yes. Please go ahead, Doc.
Do you see? Can you see?
Yes, we can see it.
Okay. Okay. Good evening, ladies and gentlemen. I see we have quite an audience. I'm very surprised for the attendance. Doctor, thank you for inviting me. This is something that that's close to my heart for many reasons. One of them being the employees, the workers, especially those who cannot defend themselves. We as professionals have to make sure that our protocols and testing practices are on such a standard that we do not harm any person. Primum non nocere, that is one of the most important aspects of the medical profession. First, do no harm to nobody, not to the organization, nor to the employees. And in South Africa, unfortunately, we have many thousands of employees really who cannot defend themselves. So it's our job to make sure that they are treated fairly. Also with regards to the organization. The organization also has risk that we must minimize. So I appreciate these talks, and I'm going to talk about the laboratory testing services for substance abuse. So before I start, I have to define laboratory testing. It's a laboratory test, it's a drug test, substance abuse. So what is a drug test? And I always, if you are old enough, you're allowed to share your mind. So the problem with ignorance is that it feels so much like expertise. And we must all guard against that always. We must never be ignorant. We must be open for someone else to convince us. Look at the evidence, think again and again, never trust our first opinion. Keep on thinking, because otherwise we may be like this, and it feels so much like expertise. And we all risk to be like that, and we shouldn't be. Okay, so cannabis use and possession is legal. So I wrote a few articles in the SA Medical Journal. I see this recording or this lecture is recorded, so you're welcome to go and look at we have one in the SM2 in the SMJ, other one the Occupational Health Journal, and the other one in the Rebus for the law professionals. Go and have a look at it, and I hope that you will be informed after that. So what is a drug test? Of course, a drug test consists of a drug testing protocol. We have a pre-analytical phase, and which involves the sampling. After the sample was taken, we go into the analytical phase. Okay, so once we are in the analytical phase, we do a preliminary test and then a confirmation test. That is the general scheme of a testing protocol. So it involves a procedure as well as equipment on a forensically acceptable standard. I know people want to run this down by saying this is mere labor law, it's mere private law. The standard is not as high as criminal law, where you have to prove beyond reasonable doubt. Well, losing your job in South Africa is just as serious, even more serious, as losing your license with a criminal record. So we must take this serious. So then after the analytical phase, where we do preliminary testing and confirmation analysis, then the confirmation analysis is done in a confirmation laboratory, like ours, expert laboratory services for drugs. And then for alcohol, it can be done either in a breath test or in a blood test. Okay, breath testing is normally more available. However, the breath test, confirmation breath test in our country, in workplaces, has much to be desired. The standard is not good. It's normally done on a screening level. I don't think anybody really do a confirmation breath test, but it would be best if we could do that. But we need to follow a specific protocol. So then, of course, all of this involves a biosample. What do I mean by that? We have to select a matrix, oral fluid, blood, breath, biomatrix, urine, etc. And then, of course, we need to have cutoff concentrations. We need to have clearly defined cutoff concentrations in our drugs and alcohol. And then for the confirmation laboratory, you need qualified personnel, good equipment that can actually give evidence, and people that can give evidence in a court of law. Otherwise, this means nothing. The laboratory must be able to back their results up. That's it. And it must have a toxicologist. Okay, so then we have a test result that comes from the laboratory, from the breath test or the blood test, and then it needs to be validated by the doctor or the medical review officer, and only then can action take place. Many people simply skip these phases and go to action immediately. Validation means the medical review officer has an interview with the employee and see is there any legitimate reason why he could have taken cannabis, for instance. Maybe he didn't know it was in his food. Maybe it's in his herbal medication. So we need to be fair towards our employees. So we have a recent case, and you will hear about this, I'm sure, the Barlow World case. And I'm not going to take over the law lecture here, but it comes down to the fact that the employer must motivate why the employee is tested for a specific substance. Look at the yellow color. In a specific matrix, oral fluid, blood, urine, etc., breath. It must be done rationally and not infringe unnecessarily on the right to privacy. That was, in essence, the outcome in scientific terms. So look at the combination, and this is now the combination must be correct. We must say, well, we have a drug, matrix, a cutoff limit, see rationally, the cutoff limit must be chosen rationally. We have a specific matrix and we have a specific drug. This combination testing protocol depends on the evidence that is required. And we need to gather information to answer that. What is the question? Do we want to prove the person is a risk to the company? Do we want to prove he is under the influence now? What do we want to prove? And gather evidence accordingly by choosing these 4 factors correctly. So the zero tolerance approach, as you heard from the doctor, must be revised. It's really outdated, and I think it's very unfair. So the judge never said it's illegal. He said we may not infringe unnecessarily. That's the word, unnecessarily. So we have the Occupational Health and Safety Act, which refers to intoxication under the influence. And this act or this law is really outdated. I think it needs an upgrade to include threshold values in matrices. Intoxication. The question is, when is someone intoxicated enough to endanger themselves and others? It's difficult to observe people who are intoxicated. How would you know they are intoxicated? Maybe they are way beyond the point where they can function safely anymore. So to wait for visible intoxication or visible impairment, it's just, in my opinion, it's outdated. It can still be done. It can still be done, but I think we owe our workforce more than that. Now be careful. Now we're going to employ a threshold value and say that, well, a blood, breath, or urine or oral fluid test result is not straightforward to assess an individual's level of intoxication. We cannot conclude from that the person is intoxicated because people behave differently, they function differently under certain drugs and the concentrations of the drugs. So now, how do we solve this problem? We solve this with a dual an impairment section or a per se section. Impairment, for instance, like if we look at the Road Traffic Act, where a person and a worker may not function in his workplace while under the influence of intoxicating liquor. So that's the impairment section, and we can also use or a per se section, which should be included in his employment contract. he may not exceed a defined cutoff concentration of drugs and alcohol in the body. So we have the two legs that we get, and both of these can stand independently. That's why I say per se, it can stand on its own. If the person exceeds this limit, then we can discipline the person and we can act. So this dual approach in workplaces can be done by observational detection or by clinical chemistry techniques. Observational detection is sobriety testing, layperson detection. Of course, this is to see, is this person under the influence? And you must be able to stand your ground, make some observations and have a witness. Or clinical chemistry, where you follow this protocol, where you do preliminary testing with immunoassay on site or a breathalyzer and do confirmation analysis. That's the per se approach. So we have these, and make sure both of these approaches are in your policy. Okay, so why do we use this dual approach? Of course, it's about practicability and to eliminate subjectivity in the case of under the influence observations. So a person can have reddened or glossy eyes, rosy complexion, you can smell the substance, for instance. That's observations that we would make. But how do we know it is alcohol? How do we know it's not a sugar problem or some kind of fallout that the person has? So they're going to claim it was my medication I did not take or some medical excuse. So what do? In this case, we would say, well, we smell the alcohol. So we single out one of these that is a good proxy or a good marker, and we introduce that in the per se section. So 0.2 nanograms THC per milliliter of blood, for instance, or 0.1 milligram of alcohol per liter of breath. So we single out the most effective one and we use that as per se. Now, we don't have to prove the person's eyes was red or he had compromised movement. He exceeded that level, and that is sufficient for taking action. This concentration level must be rational. We cannot say it should be zero. It's impossible to measure zero from a scientific perspective. A more sensitive technique will have a lower zero than another one. So it's irrational. And these levels must be chosen rationally. And that's what the judge hinted at. 0.1 milligram alcohol per liter of breath. You cannot say zero because we have always, it may be an electronic spike in your breath. There may be an electronic spike. How would you not know? So now we have to choose a correct matrix. Remember, we have those 4 factors, and the matrix is one of them. It can be blood. Sweat is not the ideal matrix. Blood is not always useful because we don't always have a phlebotomist on site or a doctor. We can use urine, or, well, hair is also not sufficient. Sometimes for pre-employment, people use hair for pre-employment. Oral fluid is now picking up in South Africa. We are the first laboratory that can offer that. And then, of course, breath. So it depends on the information that you require, on the pharmacokinetics of the specific drug, the testing technology that you must use, and the advantages and disadvantages of that specific, because all of them have advantages and disadvantages. So now let's look at the pharmacokinetics just quickly. Here we can see that the proportion of the dose in the body versus time on the horizontal axis. So you can see the drug remain at the absorption site, normally in the blood, go down typically in a matter of hours. Then it goes up in the body and all the other compartments, and it goes down even further. And here you can see as it gets metabolized, the others go down, but the metabolites goes up, and in the urine it goes up. So it depends where we want to find out if this person at that stage, at 30 minutes after use, we would probably have to go for the blood or the. So it depends on the time that we monitor, and it depends on what we want to prove. What is the evidence? What is the question that we answer? And therefore we gather evidence accordingly. At that stage, after 3 hours, you can see it's out of the blood, but it's still in the other body compartments. Or even later, it's only in the body compartments and not in the blood or in the rest of the body anymore. So it all depends on the question that we must answer, and that question must be answered rationally. So the choice of the sample matrix, typically blood or breath, you can see it's a matter of half an hour. It's very short. We know how quickly alcohol is out of the body. Urine, maybe days to weeks. Oral fluid, a little bit shorter. Oral fluid is probably the one that comes closest to mimicking blood. So therefore, we recommend oral fluid would be a better marker, a better matrix to indicate recent use, right? So a threshold of oral fluid of 2 nanograms per ml cannabis doesn't mean the person is under the influence. It simply means you exceeded the threshold, and you may act on that. You may discipline on that. Okay, and then we have hair and nails, which is not really applicable for workplace testing. But it depends on the question that you must answer. So we have these cutoffs in urine and in oral fluid. You can see for cannabis it's 2 nanograms per ml, and it's well-researched values. It doesn't mean the person is under the influence if they exceed this. It's just they exceed the threshold. It's a per se approach. And here we have the international cutoffs for cannabis, for instance, 2 in Australia, the European Union 2, America 2 nanograms per ml. Very interesting. Let me show you. Yeah, very interesting. If we go back, if one would say, all right, so I'm going to introduce, I want to go back to that other slide where I showed you, sorry about this. I showed you because this will explain it better. Yeah. So now we say, okay, if you have only THC in your body, 2 nanograms per mole, or oral fluid, or 2 nanograms per mole blood would be the threshold. But if we detect alcohol in your body, 1 nanogram THC per mole of blood would be the threshold. So my recommendation is to test them for both. If the moment you detect any one of the two, either of the two, either alcohol or testing for the other one as well, and use half the threshold values. Because the combination of those two is superimposing, like superponating, so it's not the same as having only one. Therefore, half those values, but test them for both if you find that one of them exceeds half the threshold value. Okay, so we have the cutoff values, and as I said here, what's your question? For pre-access testing or self-referrals, post-incident, reasonable cause testing, unannounced random testing, one would say current intoxication, blood and breath and oral fluid comes a little bit more close to that. And then for routine medical testing, monitoring compliance, urine would be okay. And then of course also for pre-employment testing, keratin matrices like hair and nails. So from current to history, you go back in the history. Of course, the person must give voluntary written informed consent all the time. So we have all these wonderful rights, privacy, autonomy, freedom, and health. And we want to use drugs freely, but we cannot, because the health and safety of others limit our rights. And we as the employer and as medical professionals must understand the pharmacokinetics and understand how the drug, each specific drug has its own pharmacokinetics and has its own matrix that you would be able to answer that question. I think it's very important to look at those 4 basic factors that I mentioned. Typically, the way forward for high-risk jobs for cannabis, 2 nanograms, less than 2 nanograms per mole, and 15 in urine. And then one can, for medium-risk jobs and low-risk jobs, is that. And here I have included the testing protocols, which one pre-employment for medium-risk jobs, typically. Ladies and gentlemen, that was quick, and I hope that I triggered some of your thoughts. Thank you.
Thank you, Dr. Tim. That was quite a mouthful. Please stay on for an opportunity to answer a few questions afterwards. And colleagues, as you know, from time to time, we find ourselves in a situation whereby an employee is dismissed, and sometimes the employee is disciplined. sanctions are imposed on this employee for for having been found in possession or used cannabis or even being intoxicated in the workplace. And some of these cases end up with the CCMA. And, on that note, we find ourselves having to interact with our colleagues at CCMA because somebody did not like our decision that we made in the company to dismiss the employee. And in this case, I would like to welcome our next speaker, Mr. Nkosinathi Ntuli, who has a national diploma in public management from Durban University of Technology, postgraduate diploma in labor law from University of Johannesburg, postgraduate diploma in industrial relations, labor dispute resolution practice in UTZN. And Bachelor of Public Administration from Durban University of Technology, and finally Masters of Law in Labor Law from University of KZN. He's currently a commissioner at CCMA, previously worked as a labor dispute resolution practitioner, started working in bargaining councils, South African Local Government Bargaining Council, Wood and Paper Bargaining Council, Road Freight and Logistics Bargaining Council, all in Durban. He's a qualified labor dispute resolution practitioner, as I've said, and currently commissioner at CCMA. Ladies and gentlemen, please welcome Mr. Nkosinathi Ntuli to discuss a few cases that have been dealt at some of our courts and even at CCMA. Mr. Ntuli, are you there?
Yes, I'm there, sir.
Thank you very
How
much.
are you? How are you and how's everyone? Good evening.
We are well. We are interested to
Yeah.
find out how do you decide
Yes.
that employers
Can I?
must pay people for 6 months and that cases were substantively incorrect while procedurally correct. It gets confusing, but luckily you are here.
Yeah.
Take it away, sir.
Yeah. Firstly, I would like to declare that I'm not here representing my employer. I will be sharing my knowledge as a professional and a fundi in the field of labor law and dispute resolution. Again, my master's is not complete. It's only coursework that is complete. I'm currently finalizing my mini dissertation. So, in case someone from UKZN is here and is saying, but we know this guy is still studying, so I thought let me be upfront about that. The doctor has covered partially the or partly the famous case of World. So I'm going to be as brief as possible. Firstly, I would like to start by saying a zero tolerance approach towards employees who are under the influence of alcohol and other intoxicating substances is a fairly common phenomenon in the workplace. So here in Pumalanga, week in, week out in the mines, people are caught. They get taken for discipline, and most of them get because companies most have a zero tolerance approach on especially in the mining where there is dangerous equipment. However, some workplace policies go as far as prohibit the mere presence of alcohol or drugs in their employees' systems or bodies, but is a blanket prohibiting. Pro, but is a blanket prohibition appropriate? The Labour Appeal Court recently overturned the decision of the Labour Court in a cannabis related case with very costly consequences for the employer. So, firstly, for those who are not familiar, judgments are very long, especially those of higher courts. Labour Court and the High Court, they can issue reasonable, judgments with reasonable pages that you can maybe finish in an hour or so. But when once it start going to the Labour Appeal Court, the Supreme Court of Appeal, or the Constitutional Court, you must understand that that decision is composed of many minds. So many judgments have a cut on that. So you may find a more than 100 pages judgment. So it is important that for these purposes, I mentioned that so that people, when they see me very brief, do not get surprised. Otherwise, if you were to listen to me discussing these two judgments, we would be here maybe until 11 o'clock. So let me start by summarizing, by dealing with the summary of points, important points. In 2018, the Constitutional Court decriminalized the cultivation, possession, and use of cannabis for private purposes. You will remember that was a very uh, 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 famous judgment that was issued by the Constitutional Court, and many people, including employers, misinterpreted this judgment. The Constitutional Court, by the way, the Constitutional Court is the highest court in the land, meaning decisions or judgments that are made by them, they are final, cannot be appealed. The Constitutional Court judgment did not provide guidance on how employers should deal with or manage cannabis in the workplace. So that's where confusion came from. In a cannabis related case, the Labour Court found that an employee who was dismissed for having cannabis in her system or body had failed to show that she had been discriminated against on medical or any other arbitrary ground. The Labour Appeal Court, which is a higher court now over the Labour Court, overturned that decision, finding that the employer's alcohol and substance abuse policy was irrational. So this is what the doctor was talking about, and this is what you were talking about earlier, that uh, policies, alcohol substance abuse policy needs to be rational and had violated the right to privacy in terms of Section 14 of the Constitution, as per the judgment that I was referring to earlier, 18. The Labour Appeal Court could find no rational link between the zero tolerance policy against personal cannabis use by its employees in the privacy of their homes and the maintenance of safety in the workplace. So this is where the gist of the matter is. Employers apply a zero tolerance policy against personal cannabis by its employees. However, by law now, in terms of this 2018 judgment, in their private space or in their homes, they are allowed to consume cannabis or to smoke or take cannabis for different reasons. So the explanation by employers that it affects the maintenance of safety in the workplace was found to be illegal by the court. Because remember, people who use cannabis, and I don't have this information correctly because I'm not a medical person. All I've heard is that cannabis stays longer in the system. Meaning, if I take cannabis now, tomorrow I will not be a sober person at work. And I'm expected to maintain safety in the workplace for myself and other employees. So that's where the employers were coming from. But the Constitutional Court said, no, you are wrong. You are interfering with Section 14 of the Constitution. The Labor Appeal Court also found that the employee had been unfairly discriminated against on arbitrary grounds, that there was invasion of the right to privacy, and that the dismissal of the employee had been automatically unfair. So once the dismissal is found to be automatically unfair, you must know one thing, that the court is going to be very hard on that losing party, because automatically unfair dismissals are those dismissals that are interfering with the basic human rights of South Africans in terms of the the cornerstone of our democracy, the Bill of Rights. So as a result of that, the Labour Appeal Court awarded 12 months compensation amounting to 1 million 36,794. So in general, employers may implement their own rules or policies with regard to cannabis, alcohol, and other intoxicating substances in order to ensure occupational health and safety. They also may adopt a zero tolerance approach in employees being under the influence of or having cannabis in their position at the workplace. However, a distinction must be made between the effects of cannabis and other intoxicating substances, such as alcohol, and what a fair policy should be with regard to testing and discipline in each instance. To justify a zero tolerance approach, there has to be a rational link between personal cannabis use by employees in the privacy of their homes and the maintenance of safety in the workplace. I've already discussed that above. So if an employee, for example, um, has an office job, smoking cannabis at home does not necessarily impair the employee's ability to perform his or her designated job, and a zero tolerance approach would be inappropriate. So, a zero tolerance approach in the circumstances would only be understood under circumstances where people are working under dangerous circumstances, working underground, driving big machines that can endanger their lives as well as their fellow employees. So, given the fair reaching implications of the Labour Appeal Court judgment, employers will be well advised to review their alcohol and substance abuse policies. Um, In decriminalization of the use of cannabis for private purposes, in the same judgment, the Minister of Justice had decriminalized the cultivation, possession, and use of cannabis for private purposes. It did not provide any answers about the use of cannabis during working hours, the possession thereof on the employer's premises, and what policies employers may implement. Since then, the Labour Court and the Labour Appeal Court have taken some strikes strides in developing the law in this regard. The cases that are referring to above. Now, coming to the famous Ballowet equipment case, in relation to cannabis in an employee's system or body. In the labor court, the case of Bernadette Eneva and Ballowet Equipment, a division of Ballowet SA, Pty Ltd, it's a 2022 judgment. The court had to decide whether the dismissal of an employee who allegedly used cannabis for medical reasons amounted to an unfair discrimination in terms of the Employment Equity Act. So this is very, very important when you analyze this judgment. The employee was dismissed because he or she had allegedly used cannabis for medical reasons. Remember, in the 2018 judgment, medical reasons were covered, that now for medical reasons, cannabis can be used. But at Ballowelt, an employee is dismissed because he or she is allegedly has used cannabis for medical reasons. So the court had to determine whether that amounted to unfair discriminations in terms of the Employment Equity Act, and B, an automatically unfair dismissal under the Labor Relations Act. So again, I mentioned automatically unfair dismissal like I did above. I said once the court pronounced that the dismissal is automatically unfair against any party, you must know that the court is about to come hard on that party. So you will remember the 24 months compensation of above $1 million that I referred to earlier. So the following facts are pertinent insofar as Ballowelt is concerned. The employee had more than 13 years of service with a clean disciplinary record, meaning it's a seasoned employee. A person has been with you for 13 years and has never had any warning or any disciplinary record. So the court said while safety was of paramount concern of the employer, given the nature of the equipment and machinery it operates, the employee's job did not entail contact with or operation of dangerous equipment or machinery. This is an office-based person. So if you dismiss this person for having cannabis in the system, you are in one way or another being punitive or harsh. The employer had a strict alcohol and substance policy in place of which the employee was aware. It requires employees to undergo medical tests to gain biometric access to the employer's premises. The employee who was aware of the policy failed several conservative urine tests. So there was a urine test involved here, which then showed that there was presence of cannabis in her system or body. She was not impaired or suspected of being impaired in the performance of her duties, nor was she performing any duties for which the use of cannabis could be said to be risk. So this person was a normal person, did not have an eye problem, did not have a walking problem, was a normal person. She was also not in possession of suspected of being in possession of cannabis whilst at work. So cannabis was not a position. While she alleged that she used cannabis for medical purposes, she only raised this as a defense during her disciplinary hearing but did not provide any proof to that effect. So that was her problem. That was her main problem. Because for any offense that you are putting as a dismissed employee, it cannot be that we hear about that during your disciplinary hearing. You should have mentioned to manager that, look, I'm using this type of medication. It may have me intoxicated, and here is proof from the doctor who prescribed this. It cannot be that you use it as defense now. And here they are mentioning that she did not provide any proof to that effect that she was using cannabis for medical reasons. So it was clear from her testimony at the hearing that she did not intend to stop using cannabis. All right. I'm trying to, because looking at the time, I'm trying to skip some of the information that I had summarized. So the labor court decision ultimately concluded that the employee had failed to show that she had been discriminated against on medical or any other arbitrary grounds. Remember, she said she's using it for medical reasons. Because no fair discrimination had been established, the court found it unnecessary to consider whether her dismissal was unfair in terms of Section 187, 1F of the Labor Relations Act. Although the Labour Court came to some interesting conclusions, for example, that the policy served a legitimate safety purpose and it had been rationally applied, questions surrounding the validity and fairness of a zero tolerance approach were not properly addressed. So, on the 23rd of April 2024, the finding of the Labour Court was overturned by the Labour Appeal Court. The Labour Appeal Court canvassed the zero tolerance issue at length. So usually the Labour Court would be one judge sitting and hearing the matter, issuing the judgment. But once the matter goes on appeal, at the Labour Court, you will find at most 3 to 4 judges, depending on the availability of judges, because our judiciary is very busy. So the Labour Appeal Court judgment is lengthy and difficult to read, but the court's reasoning can be summarized as follows. Remember, I mentioned the sizes of different judgment by different courts. The court found that there had been no discrimination based on any listed ground. Given the employee's recreational use of cannabis, so using it for fun, there was no basis to argue that she had been discriminated against on religious ground, conscience, or belief. Workplace policies against drug and alcohol use are standard and are aimed at complying with Section 81 of the Occupational Health and Safety Act 85 of 1993, which states that every employer shall provide and maintain, as far as reasonably practicable, a working environment that is safe without risk to the health of his employees. This must be read with Regulation 2A, which states that, subject to the provisions of Sub-Regulation 3, an employer or a user, as the case may be, shall not permit any person who is or who appears to be under the influence of intoxicating liquor or drugs to enter or remain at a workplace. So the crux of the matter arose from the fact that employees who had been tested positive for cannabis were immediately sent home for a minimum of 7 days, whereas alcohol users who tested positive could and often did return the next day to be retested. If they did not on that day, they were effectively guaranteed to test negative on a breathalyzer. If a cannabis user were to be retested the next day, they would like to test positive, even if they did not subsequently use cannabis and were no longer high. I did mention this earlier that apparently cannabis stays in the system, depending on an individual, stays in the system between 4 to 7 days. So I can take cannabis today. Today is a test day. When I'm tested, maybe by Tuesday or Wednesday, they can still find cannabis in my system. So the court described this as a situation where the employee would smoke her joint at home in their private space. Remember the Concord judgment of 2018? Sober up, and then in the morning go to work where she did her office job able and competently without posing a safety risk to herself or her fellow employees. Meaning, depending on my job, if I work in an office by myself, I know what to do. I come in sober up. Despite cannabis being in my system, I am able to do
Moenie
my
so
job
besig, okay? Hoe dan?
able and competently without posing safety risk to myself and others. Um, this is very long. Okay, I'm now getting closer to the outcome.
Yes, I think we can summarize it and conclude, Mr. Ntuli, and welcome
Yes,
questions shortly afterwards. Thank you.
yeah, I've taken too much of your time.
No, 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 no.
The court nevertheless acknowledged that workplaces have different configurations and that the conclusion reached in this case was based on a particular fact and the nature of the employee's job. So you can't be a truck driver and think that you will say you took cannabis and you go to work and think that you'll be treated as an office person. No, because with your machine or with your truck or with your tractor, you can put other people's life at risk because of cannabis. So the outcome of this matter at the Labor Appeal Court found that the employer's alcohol and substance abuse policy was irrational and violated the right to privacy in terms of Section 14 of the Constitution. Remember the Concord judgment earlier. The employee had also been unfairly discriminated against on an arbitrary ground in terms of Section 6.1 of the EEA. Furthermore, her dismissal was declared to be automatically unfair in terms of Section 187(1)(f) of the Labor Relations Act. So again, the Labor Appeal Court awarded 24 months of compensation amounting to a total of 1,036,794. This is a somewhat disturbing outcome if one bears in mind that unless the employer finds ground to challenge the judgment in the Constitutional Court, the final word has been spoken. Meaning, employers in the country, including Palo World, they have a problem with this judgment. Because unless they can find ground, remember, you can't just go to the Constitutional Court. You need to have grounds. You need to substantiate your application to the Constitutional Court, because judges are going to throw it away without even giving it a decent hearing. So the final word has been spoken. In conclusion, employers are advised to be extremely circumspect when devising and implementing policies surrounding the testing for cannabis, alcohol, and other drugs. This is particularly important if they want to adopt a zero tolerance approach, considering needs to be given to the nature of the workplace. This is very important. Nature of the workplace. So do not get it confused and think that because of this judgment you are protected. No, the nature of your work gets taken into account. You can't be a teacher and go to class under the influence of cannabis, because you are not going to be teaching our kids exactly what they need to be taught. The inherent requirements of the job, distinguishing between the effects of different drugs, the link between the result of an alcohol drug and the impact it would have on the employee's ability to do a particular job, and the threat to health and safety in the workplace. So, given the far reaching implications of this labor appeal court judgment, employers will be advised to review their alcohol substance abuse policies so that it gets in line with the labor appeal court judgment for now. Remember, earlier I said parties or employers still needs to find grounds to challenge this judgment, meaning this is the highest judgment as usage of cannabis and other drugs are concerned. Can't go to further comments. Let me here.
Thank you, Mr. Ntuli. That was quite a mouthful, hey? And I'm happy because it
One one last thing that I need to declare is
yes,
that I'm not sure if I did earlier to say I'm not representing my employer here. I'm just
yes,
here on my personal capacity and by virtue of being a professional in this field.
yes.
All right, thank
Thank
you.
you very much. Colleagues, there's a reason why Mr. Ntuli is making such a declaration. You'll remember that at CCMA, we don't have magistrates or judges. We have, I forgot what they are called.
We have commissioners.
We have commissioners such as himself.
Yes.
But like he has mentioned, he doesn't represent his employment or employer. He's just here as a professional who is knowledgeable in this subject and here to share his knowledge and experience with us. Thank you very much, Mr. Ntuli. On that note, I would like to welcome Advocate Vitam Tebele to answer some of our questions, who has an LLB from Wits University, who is an advocate at Johannesburg Society of Advocates, and he has previously worked in various law firms, different legal positions, to name a few. NBC Holdings, Posa Incorporated, and ENS Africa. Are you here, Advocate?
Yes, I'm here.
Thank you very much and welcome, Advocate. Let's start with this one. Can you discipline an employee for being drunk at work if you don't have a policy and possibly end up dismissing them?
Yes, you can. So employees are expected to act to a particular standard in the workplace. When you enter into an employment contract with your employer, what you are saying to the employer is that you are capable and able to perform the duties that are assigned to you. If you come to work in an intoxicated state, you are breaching that fundamental duty of you being able to provide your duties to the employer. I think what you must keep in mind is that policies create certainty in terms of what the rules are in the workplace, but they are not a necessity for all workplaces. In fact, policies are not prescribed by law that they must be there. It's instruments that are put in place by the employer, and in some instances by the employer and unions, so that people openly know what the rules are in the workplace.
All right. Thank you very much, Advocate. And I have a question here from Sister Lashiwe Matsule. What happens if the employee refuses to give consent for testing? Are we still allowed to continue testing?
No, you're not. You'd be violating their constitutional right. So it would depend on the nature of the workplace. I mean, both Mr. Ntuli and Dr. Lawrence spoke about the nature of the workplace. So, for instance, as an example, in the Palo Wealth judgment, the lady is office-based. She works in the office. She does not work with dangerous material or working in a dangerous environment. In that particular set of facts, unless the employee had agreed previously in their employment contract to be tested, you cannot test them without their consent. And then you'd have different organizations, like who Mr. Ntuli mentioned, the mining industry, for instance. Because of the danger that is present in the workplace, coupled with the responsibility of the employer to keep employees safe, it's usually a term and condition of their employment that you'll be tested at the gate as to your sobriety and your capability to provide the services in that environment. And in that case, it's usually a contractual term that you'll be tested. Therefore, you can't say no because you agreed to it when you started your employment. But if it's not a contract term, you can't force someone to take the test.
All right, and I think it partially answers Sister Brenda Tate's question, where she says, do we require written consent to do alcohol testing routinely? Is the consent required, or can we just call him in and say, hey, I'm testing you because I suspect you are drunk?
So consent comes in a number of ways. You can have consent in your employment contract, which arguably applies for as long as you are in that workplace. If you don't have consent in your employment contract, you would then require consent at the spot where you are testing that person. That you would have to have them consent to. So it depends which form of consent you're looking at. What lawyers will always advise you is that if you are in an environment where you need to test people because they are drunk, just include consent in their employment contracts so that it's a term and condition of their employment.
All right, Dr. Tim, Progress wants to find out that DMRE, Department of Minerals, Resources and Energy, made it mandatory for drug testing to be done at clocking stations. And all employees have to test before entering the workplace, including different work areas. You go to HR or finance offices, you must test at all stations. This is really enforced at my workplace, mining. What are the legal challenges that may emanate from this practice? Consent or method used?
In my opinion, from a medical law perspective, consent is not a continuous thing. You have to give consent for every biomedical intervention, regardless of whether it is in a contract or not. Consent is not continuous. It's not umbrella consent. You have to consent for every biomedical intervention on your body, because that information is yours. So I'm not sure how the system works there. Do you have to go through gates and continuously go through gate and blow into a breathalyzer? Probably. I think they would probably not do a urine test or something else continuously. Of course, the employer can determine the frequency of testing and where they want to test. But I think there's a challenge from a medical legal perspective in terms of consent. What about privacy? When someone is tested, we have the right to privacy for testing, auditory and visual privacy. So now people walk through gates like animals and they are just tested, taken out of the line, everybody's seeing it. What about dignity? So I think it's a violation of the constitutional right to simply keep on testing people without their consent and without the necessary privacy. That's my opinion.
Would you agree, Advocate?
To an extent, yes. What we must keep in mind is the following. The Constitution does not have an absolute right within the Bill of Rights. What you have within the scheme of the Bill of Rights is the limitation clause. I think it is Section 36 of the Constitution. And I mean, we're getting into a bit of a technical area, but I think it's necessary. So what that means is that in certain instances, a right contained in the Bill of Rights may be limited by the operation of law and so forth. So what the DMR has in place is either a regulation or a rule that applies to the mining industry. So it's a law that applies to that particular industry. And its purpose is to ensure the safety of employees within that industry. I mean, it's an industry where if something goes wrong, multiple people die. And I think the argument can be validly made that in that industry, and in other industries where there's a high mortality rate in terms of people being killed, the right to privacy and the right to possibly dignity can be limited. But what we must remember is that if everyone at the workplace is being tested, then there can't be an argument that my right to dignity, I think, is being violated because everyone in that place is being subjected to the same process.
Thank you, Advocate. Mr. Ntuli, is it legal, and this is Valerie Madi asking, is it legal to have employment contracts specify that, and I'm guessing it talks about the issue of consent, specify that by signing the consent to the policies and processes prohibiting use and handling substances in the workplace, especially high-risk work areas?
I'm just putting my back. Please repeat the question for me.
Is it legal to have employment contracts specify that by signing the consent to the policies and processes prohibiting use and handling substances in the workplace, especially high-risk work areas?
That's the key part. I was not going to answer the question. I was going to refer it to Advocate Mdebele because they are the ones who deal mainly with in my work, we deal mostly with fairness. We don't deal with whether something is legal or illegal. But be that as it may, the latter part of the question more understandable. Why would an employer put that particular clause in the employment contract? Because if it's in a high risk environment, like I was saying, it's like construction and mining, it is very important because with respect, most of the people who works in those two sectors, they are usually people who consume alcohol. So they start on Friday, they don't have time to sleep on Saturday, they continue. Then on Sunday, maybe by 3 o'clock in the afternoon, the person still does not know his name. And this person tomorrow is expected to be underground, is expected to operate a particular machine. So leaving the rest to Mr. Mdebele, I think that will be justified to have that in the employment contract. Obviously, organized labor, if there are issues that seem to be harsh, in the employment contracts, or which are relevant, then hence people must join unions, because that's their part to actually go argue that in courts for their members. But let's leave the rest for Advocate Ndebele. I think he can provide a better answer.
Advocate?
You could just repeat the question for me, please. You said,
Is it
Mr.
legal?
Ntuli, I thought I have a holiday.
Is it legal to have employment contracts specifying that by signing they consent to the policies and processes prohibiting use and handling substances in the workplace, especially high-risk work areas?
Yes, it is.
Okay.
It's not by any law from being done. I think what we must keep in mind with, for instance, if we take the cannabis versus alcohol example, cannabis can be used for medical purposes. I have not yet seen any written document that says alcohol can be used for medical purposes. It can be used as a coping mechanism, but not for medical purposes. And the fact that if you go to work and you test positive for cannabis, it doesn't mean that you are still in a state where you are not in control of your faculties, i.e., it doesn't mean you are high, for a lack of a better word. But in most instances where you test positive for alcohol, at least from the writings that I've seen, it means that you are intoxicated unless the alcohol is linked to other issues. So there are going to be differences to these two that must be kept in mind when policies are being drawn up and when policies are being applied.
Okay, Dr. Tim, how long does cannabis last in the human body system? This is Mendi Mahlalela asking.
Yeah, good question. It depends on how much you take. Chronic user may, and also in which matrix you look. So if one would look in the blood, maybe after 4 to 5 hours, of course the high is over. In the urine, it might last up to weeks. So it depends on which matrix, and again, it depends on the question you must answer. Is this person now currently, how long ago did he consume cannabis? Was it within this 4 hours? Then one can use either blood or oral fluid and set a threshold value for that. If you want to determine long-term risk, then go for the urine. So it depends on the question you want to answer. May I please comment, because the question doesn't come. The concept of zero tolerance, that's a misnomer. Zero bias our minds to 0.000. But the second half of the concept is tolerance. So zero tolerance means no tolerance. It doesn't mean zero concentration. It's completely misunderstood by the total of South Africa. So why would the government allow us 0.02, for instance? So they have lots of tolerance if we are below that, but above that, no tolerance for you. It's not zero tolerance. So the concept of zero tolerance is very unscientific as well. There's no scientist that can defend detection limit of zero. There's no such a detection technique that can achieve that. So I think it's a basic scientific misnomer, misunderstood by our legal system. The other thing that I want to say is the Occupational Health and Safety Act refers to health and safety. It doesn't refer to any other risks. So in this case of Inefer, in the Barloworld case, what about if the person works with millions of rands, make big financial decisions, but there's no risk to health and safety? So it should be a risk-based assessment, not health and safety only. Mm-hmm. Of course, health and safety is important, but what about other risks? What about company image? The other thing, the advocate referred to medical purposes. Yeah, but you have to have a medical script to be able to use cannabis for medical purposes. You cannot use it according to your own liking for medicine. And that's why policy is so important to specify that people must declare medication. So if it's a legal prescript by a doctor, yes, by all means, that must then be declared. You cannot simply because it's your choice to use this herbal medication with. That's not medicine. It's self-medication. It's not legal medication. That's why also people have to declare something like a benzodiazepine. It's prescription medication. They cannot use it whenever they want to. So these were just a few comments that I think we have to keep in mind. The main thing here is the zero tolerance. How can that be translated from a scientific perspective to zero concentration? Scientifically, you cannot make that jump. I think it's a total misnomer and a total misunderstanding by our legal system.
Thank you, Doctor. Advocate, I think I'm throwing this one at you and Dr. Tim here. What happens if a person does not consent to testing? And this is Giselle asking, how do you proceed? Do you proceed by assuming that he's drunk and treating him or her as if he's drunk? Or what is the best way to proceed in this case? Let's start with advocate.
What is the best way to proceed in what circumstances?
If the patient or the employee refuses to give consent for testing. Let's say you can see that this patient or person is intoxicated. What do you do?
So I think the starting point is that as an employer, you have a responsibility to ensure that they are safe, and two, that the workplace is kept in a safe manner. There'll be instances where you do not need to conduct a test in order for you to establish that the employee is breaching that fundamental rule or is making it impractical or impossible for you to ensure safety in the workplace.
Mm.
So that's the starting point insofar as you don't have a policy or you are not allowed by law to conduct a test. And perhaps just to complete the circle, the Employment Equity Act, and in particular Section 7 of the Employment Equity Act, allows medical testing of employees in circumstances where legislation permits it or it is justifiable in the light of the medical facts, employment conditions, social policy, the fair distribution of employee benefits, or the inherent requirements of a job.
Mm-hmm.
So in those circumstances, you could find protection or you could find the source of the power to do the testing under Section 7 of the EEA, Employment Equity Act.
Thank
But
you.
you can still,
Dr. Tim, proceed.
yeah, you cannot pin them down. They have freedom of choice. You cannot pin them down and say, we are going to force you now. Rather, arrest him, let security arrest him and get him off site. You have a duty to ensure safety. And then follow the rest of the procedure. So he could be, what you can do is to say, well, you did not comply with our policy, as the advocate said just now. You did not comply and we're going to discipline you on that basis. But one must be careful to label someone as intoxicated if you don't know what the substance was, or if there was a substance at all. So your suspicions need to be realistic. You have to have a reasonable suspicion.
Thank you, Doctor. We'll take 2-3 last questions. Who is responsible to determine the rationality of the workplace at workplaces that do not have an occupational doctor or at least a sister? So is it an HR person or who is responsible to determine the rationality in the workplace? Can I ask Mr. Ntuli or advocate?
Um, in my experience, the person who's ultimately liable for everything that happens in the workplace is the CEO, and the CEO assigns certain of the powers to various people. So in places where you don't have a specialist, usually the custodian of the policy is HR, which therefore means that HR is responsible for those things.
Okay, thank you. Advocate?
Well, that was me speaking. Perhaps Mr. Ntuli wants to comment.
Oh, okay. No, it's not a problem. I think it's sufficiently answered. The next question is there a matrix to indicate the impact of cannabis in altering behavior and physical and mental capabilities? I believe that although employees' job may not be safety critical, this practice of taking cannabis may be counterproductive to the building of safety culture in an organization. Dr. Tim, do you want to take it away?
Sure. There's no one single matrix that can tell you that the person is intoxicated. Let me put that quite emphatically. You cannot say because you detect a drug in someone's blood that he is now under the influence. You may have reasonable suspicion, but people respond differently to drugs. There's no hard and fast rule to say if you are above a certain level, you are intoxicated. Don't go there. That's why I say function on a per se level in terms of practicability. There are research that has been done. I have published that recently in the SAMJ, where a certain fraction of people above a certain level are intoxicated, but 40% of them are not intoxicated. It doesn't show signs of intoxication. So it really depends on the person. And that's why there's no hard and fast rule to say you are above a certain level, you are intoxicated. Not in blood, not in other fluid, no matrix. So be careful to make that statement. So that's why I say use a per se approach in the contract, per se approach, and say if you exceed this level, we're going to discipline you, and this is on its own, it's sufficient reason, or in observation type of approach. That's a different ballgame, but include both of them. But yes, no, there's no specific concentration that you can tell this person is under the influence. Those two doesn't go together.
Thank you, doctor. And I'm throwing this one at all of you. When we do our medical surveillance, we often stumble upon employees who will test positive for, let's say, cannabis or opioid or any other drug. But specifically referring to cannabis, is it fair to declare that employee unfit, even though there are no symptoms of intoxication, just on the grounds that there is a positive cannabis test? Is it fair to say you are not fit to work, therefore I'm not recommending that you get employed? Let's start with advocate.
I don't think it would be because as I understand it from a medical perspective, you could test positive for cannabis but be fit to work. So I don't think it's something that automatically follows that when someone tests positive for cannabis, then they are unable to work. So because of that reasoning, it would not be fair. And I mean it's something that is put in the Ballot judgment because if you look at that reasoning where they say if someone who tested positive for alcohol today comes back the following day, they would in all likelihood test negative for alcohol. But if someone who tested positive for cannabis today comes back the following day, they would still test positive for cannabis. So I don't think it follows just from the test that you are unfit to do your duties.
Thank you very much, Advocate. So from you, it is not fair. Dr. Tim, is it fair to say you're not fit to perform this job because you have a positive urine test? And I've clipped it or I've stapled it in your file. So I'm recommending that you're not given the job. Is it fair or unfair, sir?
Well, let me approach it from this side. You know, what is the question that you want to answer? Is the question, this person, there's a big chance he's under the influence now. Do you do, for instance, a breath test for alcohol when they come in for medical evaluation? Or do you do a urine test for cannabis? You answer two different questions. The question you want to answer in that case, is this person's drug-taking behavior a risk to this company if medical surveillance consultation? Is the drug testing behavior to the company? And certainly, if you find X nanogram per milliliter in the urine, you won't be able to answer that question. You won't be able to answer because cannabis is legal and this person may use cannabis. On the other hand, if you want to ask, is there a good chance that you used cannabis 4 hours ago? You cannot go on site now, testing in blood or oral fluid. So it depends on the question that you want to answer. So in that case, rather look at liver function for medical surveillance, liver function and many other markers that you can use. I'm sure the doctors are skilled into. What do you look for when you do alcohol medical surveillance? You look at liver markers like gamma GT, CDT, etc., mean corpuscular volume, red cell volumes as well, the ratios of liver markers. So I would say rather look at those, because the fact that you detect that substance in urine doesn't mean this person is unfit for work. On the other hand, if you would detect heroin in his urine, you know this is a dangerous substance. And then you can obviously then investigate further. So it depends on the substance, it depends on the marker, and it depends on the question you must answer. It's very important to gather evidence to answer the question.
Thank you, Dr. Tim. And lastly, distinctly, what is your take? Should we declare this person fit because we can see that they smoke cannabis, even if they are not intoxicated at the moment?
Um, I would borrow from my earlier presentation insofar as the Labour Appeal Court judgment is concerned in the Barlow world, the nature of the job. If it's an administrative position, it wouldn't be fair taking into account the nature of the job. But if it's a construction employee or a mining employee operating heavy machines, then for me, it will be fair that they are not allowed to continue with the duties, and disciplinary action may be taken as well. But for a person who works in an office environment, a person who works by herself, who cannot endanger anyone, it's a different story. So for me, it's all about the nature of the job. Let me end there.
Thank you. Colleagues, I believe we have all come to the conclusion of our session. Just one last question I have for Dr. Tim. If we are in a position as healthcare workers to take a blood sample, let's say it's a night shift, if we are in a position to take a blood sample or any other sample and we want to get it to the lab as soon as possible, is expert laboratory services open at night, or do we take it, put it in a fridge, what are the basic storage conditions that we can consider should we want and obviously have a consent to collect a specimen, especially after hours? Do you have different labs or do you have one reference lab that handles all the specimens?
We have this one reference lab because the methods that we use are highly specialized. So what you can do is contact us. We will give you the necessary blood tubes to the cannabis in the blood, keep it cool, and we can send the courier in the next morning, and you can have your answer in 48 hours. But you need a specialized blood tube, not a glucose tube they use for glucose analysis. This is another type of specialized tube, and we can provide you with that. Just phone us or email us. I have posted my email address in the chat section. You're welcome to contact us. But then you keep it in the fridge and we will send the courier to fetch it from you.
And will the advocate not challenge the quality of the specimen based on the fact that it was placed in the fridge, or Mr. Ntuli challenge the validity of the specimen once the patient has been dismissed?
They are welcome to. I see my way through.
Okay. On that, colleagues, I would like to close this here by saying that thank you for joining us on this fruitful and informative evening. We look forward to our next installment on the 27th of March, when we'll be discussing how we can ensure our workers to minimize their financial suffering during injuries and incapacity. From all of us colleagues, good night. Have a blessed evening.
Thank you very much.
25.